All right, hello again. This is Ben Hitchcock Cross talking to you today. We've got it. The logo, and we've got Ben, and we're rocking and rolling. I don't know if you noticed, but I try to keep the borders and the lights with the seasons here. I don't know where you live, but Wisconsin is a jungle. It's just only 4 months out of the year, and it's pretty deadly out there. There are trees that I planted I can't even see, and there certainly are mosquitoes all over me. But all right, that's how it goes. So where we left off, and we're doing sort of this trauma story of a couple, but basically we're talking about bias at the Department of Workforce Development, Equal Rights Division, and sort of how they're structured to get to really they're having a hard time dealing with cases involving the state of Wisconsin or other government entities. I think that's really the theory that we're working through here. And if you don't recall, what we were talking about before at the end is I'm dealing with an administrative law judge, John C. Galhard, and I'm trying to depose Secretary Petchacek and Secretary Carr for depositions because Secretary Carr was the decision maker at the Department of Corrections when these issues went down, and Secretary Petchacek was the undersecretary or deputy secretary at the DOC when these issues went down. So we wanted to find out what they knew and when. So this is all about how we were prevented from doing that. So again, motion gets quashed. I just found this out today. I'm going to tell you in a second. But the big question was, how does the judge learn about things off the record, outside of the record, and that is the holiday plans of Secretary Petchacek. So there is some question about that. I think I certainly have that. And again, there are statements by Maria Selsor, Secretary Petchacek's office, individual ALJs, all of the fact that Secretary Petchacek does not have any effect on the work product of ALJs. By the way, I've heard it pronounced Pahasek now. I'll take your word for it. I'm from Milwaukee. I'm happy to pronounce your name any way you want. She does not live very far from me, which is a hilarious coincidence, but that's Wisconsin for you. So, yeah. All right. So we're doing, we were trying to get them there. So I just am going through a bunch of responsive emails, public records. Here's a big difference that is in this case, because remember, these guys are not judges, although they have the term administrative law judge. It's fair to say, and the user gave this comment, which is attorneys employed by the governor of the state of Wisconsin. And I think that's fair. And because it's true, the statutes say that. So, okay, these attorneys that are working for the governor of the state of Wisconsin here, for some reason, so they're not members of the judiciary, and they are subject to public records requests. Fair enough. And remember, we have had this problem ongoing with them, which is they say that there's certain emails between particularly certain ALJs and Maria Selsor, and they will say those are deliberations. We're not going to give them to you as public records. We'll give you other things, but not those. Okay. I think that's absolutely wrong. I don't know if the ALJ is the only one making a decision, there can't be deliberations. They can't meet in closed session. They've got a big problem there. I think they know it, but we'll deal with that later. Okay. So this ALJ, by the way, does this motion to quash, and basically what he's doing is saying, because everything's so soon and this and that and it's so rushed, I'm just going to quash the thing and then we'll decide it later, okay? And what does he do? This John C. Galhard, administrative law judge or attorney working for the governor of the state of Wisconsin, he sends a courtesy copy that day to Maria Selsor of his motion to quash. So there's no connection at all, and she doesn't directly supervise her, but his supervisor, for some reason, needs to know that he successfully quashed the subpoena. My guess, and I'll tell you because I think they've slipped a couple times recently, There were other communications between Gelhard and Seltzer on this subject, but hey. So, if you remember Ann Molitor, she is the ALJ on the Lucky case. As far as I know, she resigned her position with the state as of June. But I have an email from her, and I'm going to paraphrase though, but it's from her to Maria Seltzer saying, I'd really like to get this out. Am I okay to send out this draft? And that's problematic because why would she be asking if it's her decision? Why would she be asking somebody else if it's okay to send out the draft? And I would be again concerned. I have this case, the Lucky case, for example, before Molitor. But if I had other cases before her, I would be concerned that those decisions were not actually written by her, and it's problematic. So I think that that's just a for example. On the Folleron case, for example, and again, I think they've slipped up. We've got emails from Reinhardt, the ALJ on that case, talking about going through a draft. And luckily, in that public records request, they gave us the first draft of his motion to recuse himself in the Folleron case, his own decision to recuse himself. And it turned out that Judge Reinhardt wrote a 2-paragraph motion, and which draft, I guess you would call it, because he didn't really write it ultimately. He then sent that 2-paragraph draft to Maria Seltzer. She was out on some leave at that time, so couldn't get to it at the moment. But his theory, Peter Reinhardt's theory to Maria Seltzer, his superior, when he was discussing this, was simply, I think less is more. Well, Maria Seltzer might have different views because she added several paragraphs, including some on the, and the issue there is that Calvin Furman is an ALJ, and Calvin Furman is also the former deputy superintendent at Milwaukee Public Schools, among other things. And so he was going to be a witness in the Folleron hearing. And it's my understanding that we explained this to him at least 6 months, possibly 8 or 10 months beforehand, depending on how you look at it, that we intended to call Judge Furman as a witness in this case. Unfortunately, the Judge Wade didn't respond on that issue at all, no matter how many times we raised it, until the day he was going to be a part of the group of people that listens to a candidate for employment for a permanent position. He was going to be on that committee. Thank you, Ben. You're welcome. For Calvin Furman to get a permanent position. So it was only on that day that Judge Reinhardt was going to be on the committee for Judge Furman, that Judge Reinhardt recused himself from the case. That happened to be 13 days before the Folleron hearing, and some 4 months ago, and she's been waiting for her day in court ever since. Kind of shocking. So just, again, why we got on that subject is only that trauma, A, and B, because there, in my mind, is pretty good evidence that Maria Seltzer and not the judges are doing anything on that, making decisions, I guess is the key question. I've raised this issue with at least Peter Reinhardt. He's never responded. I've raised this issue with Maria Seltzer. She's not responded on the facts of this issue. I've raised it to Judge Benitez Morgan. She's only responded by ordering me not to discuss Calvin Furman and Maria Seltzer anymore. She calls it something else, I think. But I've raised it to the Secretary of the Department of Workforce Development. I've certainly raised it to Ramona Natera. I believe I've raised it to Ramona Natera. I should have raised it to Ramona Natera if I haven't. And I can tell you that I have not gotten a substantive response on how it's possible for ALJs to be the author of their decision, yet they're sending drafts that are being altered and then ultimately written. I mean, what do you call it? The person who's got the final draft is, in my mind, the author. I don't know how you feel, but that's where I'm at. So that is what I'm talking about in terms of problematic. So, okay. That's my opinion. So and again, I'm not really aware of any of this because now we're flashing back to December of 2023 here. And I am dealing more with John C. Gellhardt. And we have basically a discovery dispute, okay? And we have a dispute about whether or not it's appropriate to ask certain questions about the complainant's sexual history, for lack of a better word, when the issue is that she was sexually assaulted and how the Department of Corrections dealt with that. Okay? So we refused to answer certain questions, I believe, based on that objection, and that was cause for concern, let's say, by the other side, the Department of Corrections, which, fair enough, they have every right to raise those issues, no problem. The judge ordered me to pay for, I think even personally, but I may be wrong, ordered me to pay for a redeposition of my client. Which, again, may be perfectly legitimate behavior. I couldn't say. The problem there, well, I could say. The problem is that his entire motion was based on the decision, I should say, was based on two things. A statement from the Department of Corrections attorney, and why I'm putting it that is that's not evidence. That's just a statement. That's the opinion, I guess we should say, of the Department of Corrections attorney that we walked out or stormed out of this deposition. Now, in fact, nothing like that ever happened. It's very clear that I asked my questions. She finished her part of the deposition. I asked my questions, and then we asked them if they had any more follow-up questions. They asked some more questions, and then we left. But by no means did we walk out of the deposition. I think we were very clear which questions ahead of time that we weren't going to be able to answer because we thought they were improper and like that. Okay. All perfectly fine. Which wasn't perfectly fine was, again, the judge decided based on her opinion that we walked out. And, people make mistakes. They read things. Again, you got to have evidence, not just the opinion of an attorney. And you might have the transcript right in front of you, which shows that we go back and forth. But okay, people make mistakes. Then, beyond that, he ordered me to pay these costs. Well, the problem with that is that you have to have a hearing on that subject. That's how it goes. If I lose a motion to compel or a motion, other discovery motions, the presumption is that the loser pays some fees to the other person. That's just what it is. Certainly that way in federal court, less so in reality, I would say, in Wisconsin state court, but, whatever. So, whether or not there's a presumption before the government is going to take some money from somebody and order it to some other person, you first have to have notice and opportunity to be heard. It's just the rules. And again, these guys had really big problems following the rules, as we'll see, and especially notice and opportunity. That is a theme here with them, that's a problem. So I raised this issue saying, look, you can't just sit here and here's the statute. Now, it's going to get worse because in the statute, what the judge quotes is there's basically three clauses in the statute. He quotes the first one, he quotes the third one. There's no mention whatsoever of the middle clause. Hey, that's the due process clause in there. That's the one that says after notice and opportunity to be heard, then you can go get them. He omitted to enter that. He excised it. Now, in a situation like that, I'm going to do two things. I'm going to point out to the judge, one, you've got the facts wrong. You say that we walked out, but the facts that you have in front of you show that we didn't walk out, as, by the way, we explained. But also, number two, you relied on the evidence of a statement of an attorney, which, of course, what attorneys say is not evidence. Say it with me now. That is a very important thing for everybody to understand, and that's something that skips up pro se people all the time. What attorneys say, what you say is not evidence, that because you're advocates or a party, and used to be parties couldn't even give evidence, remember that? You have to come and get competent evidence, meaning someone to come in and testify under the right parameters, okay? That's the kind of evidence that they want. All right. So, again, we raise this issue. You can't just, and a judge, any judge can't just say, hey, the light was yellow if one witness says the light was red and the other witness says the light was green. Can't do it because there's nothing in the record to support that conclusion. And that's, again, here, there's the only thing in the record to support the conclusion that we walked out is the opinion of an attorney. It might be signed as an affidavit, nevertheless, it's an opinion. And two, it's contradicted by the actual transcript that was provided for you. So that's problematic because, again, you can't make a decision based on your feelings that you've, taken over from this other attorney, and it's kind of getting to be evidence of bias, but okay, well, hold on. The second thing, and I think that was by far the most damning, is that the judge left out, and it's very possible that he was pushed first on what about, you can't do that. And then he responded, yes, I can. Here's this statute, and look, here's the first clause, and here's the last clause. That may be a little bit more likely. Again, I'm paraphrasing and sort of trauma recalling here, but and we will get into specific shows on all these issues here. But again, he excises out the middle part, at which point I kind of refuse to let that go. Either of those issues, by the way, until the days of the hearing, I refuse to let those go because both the attorney for the Department of Corrections had a duty to correct this document here. So the judge signed a document saying we walked out of a deposition. Both the attorney for the other side had a duty to correct it. She didn't do that. And the judge had a duty to correct it because he's an attorney too. He didn't do that. He just continued to go on. What he did was modify his orders slightly. And this is, you see this a lot with administrative law judges as part at the Department of Workforce Development. That's what we're talking about here is they will do something they're not allowed to do. And then instead of undoing it, they will take 60% of it back. And then, instead of starting on a basis of law, then they'll say, well, what do you want? You gave you 60%. Never mind, you're still doing 40% that's illegal just for starters. But hey, that was the tone there. So, hey, Ben doesn't have to pay for this thing, and we'll go from there. Okay. Meanwhile, I'm also pushing the issue of, seriously, you need to retract your statements about my religion. And I think we didn't talk about that last time. But let's remember, I push back on, he says there's other people have holiday plans. And I'm like, well, A, that's not well received because you made us spend the whole week of Hanukkah moving around. And now you're privileging, when you say holiday, you're really talking about Judeo-Christian holiday. Remember that one. And then number two, when you're talking about you have knowledge there of their plans, and you're privileging specifically. I'm asking him, who are you talking about when I'm saying I cannot believe that you put on a public record your opinion about my religion? Because his response was, thanks for sharing with us that you're Jewish. Now, remember, Maria Salsor has reviewed that and found it to be professional. So we'll see how you feel about that one, because we'll, of course, focus on that one. So, yeah, that is something. So then, just looking at the time, we're at 20 minutes, we're doing all right. Okay. So similar thing. He retracts from the record his comments about the Jewish, but leaves the letter in there. And also, by the way, that is very similar to, he puts in that same letter that if you think that I'm biased in favor of Secretary Petchacek, then you should go remove your case to federal court. And then when we don't instantaneously remove our case to federal court, he says the fact that you didn't remove your case to federal court is evidence that you don't think I'm biased for Secretary Petchacek. Which is also a really serious fallacy, on par, in my opinion, in terms of logical destructiveness or incoherence, although it's, maybe religiously sound. It's just, to say that you need to give up your rights, and the fact that because if you feel that I'm biased, and the fact that you haven't given up your rights, means you don't think I'm biased. Is just, is that the kind of person that you want to be? I guess I will depersonalize that, but is that the kind of opinion that you want guiding your administrative law judges? Because it's just so obviously wrong, both in terms of logical. It doesn't, obviously, you can still stand up to injustice at the Department of Workforce Development and at the Department of Corrections and still maintain your opinion that there's bias. And he put that in writing possibly 3 times. And I think that's, again, which means it was bounced off and discussed, in my opinion, with Maria Salsor. If he feels like he can put it in there 3 times. And again, it's problematic, because it also fundamentally undermines the Wisconsin Fair Employment Act and Title VII. And these are people who are supposed to be interpreting the Wisconsin Fair Employment Act and enforcing it, and it's a big problem. A big problem. So I'm absolutely not giving up on these issues, and we are coming down to a few weeks before the hearing. And I think we just get one decision after another from him. I definitely finally in the end, I think I'm pushed and make a motion to recuse him. And he does, it's basically more along the same lines, we'll read it, but ultimately it's, I'm not biased because I didn't always rule against you. It's one thing when you spend a whole day researching the law, and it's another whole day, explaining it to somebody in writing. But when they just don't, it seems like they don't even bother to, you put the law in front of them, and they don't even bother to set out the standard or review why their actions would be in accordance or not with that standard, or in fact, why that could be the standard at all. And just say, as a matter of law, I've decided that I'm not biased against you because I ruled in your favor at least once. I don't get it. But that's where we were at with him. So we, at some point, I start to figure out that I'm not getting mail that other people are getting. Sometimes they're emails, and sometimes they're just straight up paper documents that I'm not getting. And sometimes they're extremely important, and other times they're not. And at that point, I go down to the state office building with my paralegal, and we go and meet Heidi Marshall, the like executive secretary of the department, who used to be the regular secretary there when I back when in the day when I just used to be a paralegal running documents back and forth. So that's funny. Anyways, she and I get together, and I start asking for a bunch of documents. And I then come back and want to subpoena somebody. I don't know if it was Calvin. I don't know who it was. But I go there to subpoena somebody, and they, at that point, because they now have their guard up, Heidi Marshall refuses to come down. And she, yeah, it's kind of shocking. She refuses to come down. So they tell us that we have to call this number. So I call this number, 608, downtown Madison, and I talk to the secretary there, and I explain to him my problem, and lo and behold, Ramona Natera gets on the phone, and I talk to Ramona Natera. That's Maria Seltzer's boss. And I'm like, gee shucks, Ramona, I keep copying you all these complaints, and you keep never responding. I wonder why that is. And gee shucks, Ramona is like super nice to me and tells me that she's never receiving my complaints as complaints because they're all about ALJs, and they're under the supervision of Celsor. But if I make a complaint about Celsor, then she'll deal with it. I'm like, wow, that's fascinating. And I start to wonder again, maybe we'll have some positive response here and actually get them, because what's the goal? It's not to chase around a bunch of ALJs and make people's lives difficult. It's to get them to follow the statutes and their own rules. Just nothing more than that. Nothing more or less. But no, I'm not going to accept anything more or less. So that's what the difficulty is there, because, again, the pathos there is that we're going to make up the rules. I think ethos. Sorry. The ethos there is that we're going to make up the rules as we go along, and you need to cram it. And I'm not going for that. So, all right, we are about to get to the build-up to the big sort of clash there, and there's two hearing events that we're going to talk about. But hey, I, in the course of all this, am figuring out that I'm not getting my mail. I start to do a round robin of everybody. And I start to look at all of the notices that everybody, all the ALJ sends, all the documents that I get. And on this particular case, the notice that I got from them was no notice. And I realized that there was some statutory requirements that the notice need to have, and that they hadn't provided any. And in fact, the problem for them was the notice had to be done 10 days in advance. And here we are 9 days ahead of the latest hearing, and I'm calling them up saying, seriously, guys, what's the deal with the notice here? Now, instead of responding on the rules, on the law, or the facts, or anything else, Maria Seltzor's position is, you attorney should give me the complainant's email address, and I'll email them the notice. Notice turned out to be a WebEx invite. That's what they meant when they said notice, not what was in the statutes, but a WebEx invite, and we'll send that to her. So, of course, I didn't go for that, because the statute, there's no part of the statute that says you can email any of it. Any of the notice, there's no part of it. And I pointed that out to her. And instead of responding on that issue, she again, let's say, I would say kind of went after me. Let's put it like that. I thought that was problematic, but here we are 2 days before the hearing, And I think they have no notice. But in addition to that, what happens is the judge says that we're not going to hear any motions at the hearing. There'll be no statements of any kind. I can't. Carr and Petchacek have no bearing on the case whatsoever, so they're excused. Remember, Kevin Carr is being removed from the Department of Corrections because in September of that year, it had come out that there at the Waupun Correctional Facility there were 3 prisoner deaths under his watch. They charged criminally a bunch of DOC people, but ultimately the buck stops with Kevin. But Tony Evers, it seems to me, masterminded a way for him to get push him out the door without actually having to say that's why they were doing it. So that all of those decisions had just been made, and now here we're having a discussion. They also objected to a bunch of discovery and said that they didn't have to respond, and then told the judge that I was not a notary. Now, why did that come up? Because I think I notarized one of the documents. I think that's the allegations there. One of the discovery responses by the complainant. And for some reason, of all the issues that we had raised, the only issue, and I'm going, going through the fact that he misquoted the law seemingly on purpose, the fact that he made a punitive decision based on no facts, on facts that were, and then he refused to reconsider. And when he did reconsider, he then only mollified part of the decision, but still it was completely lawless and he couldn't justify it. And then we went from there. So instead of addressing all of the issues that we just discussed, his main and only concern was I a notary? And the problem with that question, which may be a legitimate question to answer, I don't know, asked, the problem is it wasn't noticed, and the statutes require it to be noticed. Okay. So we're going to get there, and that's what we're going to talk about next time is what happens when you try to object to John C. Gelhard's demands. Is he going to stand for that or not? That's going to be the question. Is he going to allow you a stoat box or not? So the secret, he rage quits is the answer. All right. Can we do this? Rock and roll. So, I hope you can understand why so much of this is so hard to deal with here. I hope you appreciate this long form explanation. And thanks for sticking with us. We'll keep you informed. Or something.